Appeal in the matter of Michael O'Higgins, FX Class Representative Limited, and Evans and others.
May it please the Court. I appear together with Mr Robertson, King's Counsel, and Ms Bird on behalf of Mr Evans, who, as your Lordships know, is one of the proposed class representatives of PCRs. We have Mr Joel, King's Counsel, Mr Rothschild and Ms Thomas on behalf of the Michael O'Higgins FX Class Representative Limited, otherwise known as the O'Higgins PCR, and Mr Kennelly, King's Counsel, Mr Luckhurst, Mr Sebastian and Ms Higgins on behalf of the respondent banks. Now, your Lordships will be pleased to hear, I hope, that the parties have been liaising as to the best way of presenting the various issues which arise in this set of appeals and judicial reviews.
Yeah.
The way that we propose to divide things up, subject of course to your Lordship's views, is as follows. Today, you'll hear from me and from Mr Joel on the grounds of appeal which relate to the opt-in, opt-out decision. And we have tentatively agreed to address those various grounds of appeal in 4.5 hours, so 2 hours and 15 minutes each.
Right.
Subject to this agreement that if one of us were to go long or to seek to go long, it wouldn't eat into the other one's time and it would have to be caught up in some other way. Mr Kennelly will then follow, responding to those grounds of appeal. His position is this, that he thinks he would like broadly the same amount of time as Mr Joel and I have taken, but subject, of course, to what he actually needs. So he makes a plea for parity, but he may not, in fact, need all of that time. And then we will have Mr Joel and I responding after Mr Kennelly for 1.5 hours in total. Now, as between Mr Joel and me, we will divide up the submissions as follows. And I'm afraid, perhaps slightly unhelpfully, but I hope this will aid clarity of exposition, we're going to address the grounds out of numerical order. So I will start with my ground 2. So my ground 2 is the ground that the tribunal erred in holding, on the one hand, that the proceedings would not in fact go ahead on an opt-in basis, when on the other hand purporting to make that order that was the basis on which they should go ahead.
Well, that's the opt-in, opt-out issue, isn't it?
So all of these grounds of appeal are to do with opt-in, opt-out, my lord. So ground 2...
And one way of looking at it is that this was a very early decision, and it was before a number of decisions of this court, including La Patorelle and Lutman.
Of course.
And it might be said, well, that the CAT might have taken a different approach if it had had the benefit of our judgments in those cases. But you would no doubt argue that, and Mr Joel will say, no, that's absolutely nonsense. Sorry,
Mr Joel is with me
yes,
on that. Mr Kennelly against me.
We'll say, no, that's absolute nonsense. It was still the right approach.
Absolutely, my lord.
But I mean, that in a sense, it seems to me at least that is the central issue, because in one sense, I mean, the carriage issue is a different point.
It is.
But the point about the striking out point, if I can put it that way, in a sense, is dependent on the opt-in, opt-out point.
It is, my lord, it is, yes. So we have opt-in, opt-out, and as part of that we have the error in saying, well, it should go ahead on an opt-in basis, even when that's not viable, it's not possible. I'm then going to address my ground 1, which is whether the tribunal even has the discretion to consider opt-in, opt-out. And I'm then going to address ground 4, which is practicability. So that's one of the 2 considerations for opt-in, opt-out. Mr Joel is then going to take over the baton from me. He's going to address anything extra on practicability, which he needs to address. That's his ground 2. He's then going to turn to his ground 1, which is strength of the claims and strikeout, as your lordship just adverted to, which is very closely linked to this decision. And you'll then have me sweeping up for the appellants on opt-in, opt-out, broadly speaking, for strength of the claims, strikeout, and my additional ground 5, which relates to some of that add-on criteria which we're taking into account factors.
So when do you fall out with each other and deal with carriage?
Wait, on carriage, exactly. But for the next 2 days, it's all sweetness and light, my lord.
And just so we know, I mean, this case is down for 3 days. You think you're going to need the full 3 days, do you?
We do. We do, my lord.
So we aim to finish, please, by 4:15 on Thursday.
We'll do our very best, absolutely. We take that.
Okay.
So
Right, thank you very much.
that's the appeal. And if I just flag what's coming on day 3, so that takes up 2 days, and then we have the carriage appeal on day 3. So that will be Mr. Joel, and then Mr. Robertson for the Evans PCR, Mr. Joel again in reply, and then we have a very short costs judicial review, which is tagged on to the end, 20 or 30 minutes, pursuant to the direction.
Is that why Mr. Williams is on our list of counsel?
It is, and he's also there to the extent that he needs to address any of the cost issues.
He's not here, is he?
He's not. So all funding ATE cost issues are going to be addressed on day 3,
Right.
in order to best use cost counsel's time.
Any excitement that we can look forward to?
It will be extremely exciting, I'm sure.
Okay.
In terms of the bundles, and I do apologise that they have splurged rather, but I think I'm right in saying there are 4 sets of bundles. There's a core bundle, an authorities bundle, a big supplemental bundle, which we will go to on occasion, and then a key documents supplementary bundle. And my understanding is that the big supplemental bundle has been provided in electronic form only, but your lordship should have the others in hard copy.
Yeah, that's fine.
I'm grateful. If I start then straight in with my ground 2, since I know, of course, that you are an extremely knowledgeable court in relation to this regime, so I don't propose to open up the regime at all. I'm just going
Just
to
a
read.
moment, just a moment. Oh, yeah. Yes, sorry, my lord reminds me, just formally, we hadn't had a response, I don't think, from Mr. Kennelly in relation to my email of yesterday. My lord having met Mr. Higgins socially.
Well, we have just emailed, and apologies for not doing it sooner. We have no objection or concern to that.
And I'm very pleased to hear it, because it did seem to me rather like regression analysis. If you take it too far, none of us will be able to do anything at all. Including you lot. Thank you.
So ground 2, the majority of the tribunal erred in law in deciding that proceedings that should be certified and which could only be brought on an opt-out basis were not entitled to be certified on an opt-out basis. So if I could ask your lordships to turn up the judgment, which is in Core Bundle Volume 2, tab 14, page 236. And if we start perhaps on page 238, which is the contents page. Now, on occasion, I found the structure of the judgment perhaps a little difficult to navigate, and so I thought it might be helpful just to start with the contents page and set out the most important parts for the purpose of my submissions today and the submissions tomorrow. So we have under part 5, which is halfway down between the hole punches, the relevant criteria in general terms, and then we have section C, the opt-in, opt-out issue, and that's where the principal legal directions are. Then we have part 6 at the bottom of the page, strikeout. That's a long section which Mr. Joel will be addressing. That goes on for about 80 pages, you see it on the page. And then we have part 7 we can skip over, part 8, which is on page 240, again towards the top hole punch, weighing the relevant factors and determining the issues before us. So that's really where the dispositive part of the judgment is to be found. And we see in particular section C in part 8, the opt-in versus opt-out issue. So those are the main parts of the judgment for my purposes. I'm going to take you through the main references relevant to this ground of appeal, and relatively quickly if I may. So if we look at paragraph 364 of the judgment, which is on page 423.
Sorry, 423.
423. So we're in section 8 now, we're in that dispositive part of the judgment. The tribunal is determining the issues, or the majority of the tribunal, I should say. And we have paragraph 364, we conclude that each application, if it were the only application in issue, could and should be certified as collective proceedings. In short, both applications succeed in relation to the certification issue. I'll now turn to the various occasions on which the tribunal acknowledges that the present proceedings will not go forward on an opt-in basis. So first of all, flicking back through the judgment to paragraph 99,
I don't think there's any dispute about this, that it was common ground between all the judges, that if it was opt-in, it would wither on the vine and die.
Absolutely, my lords. And so I can maybe take this quite quickly, and your lordship can see how not only was that agreed as a matter of fact by all of the judges, but it was baked into the majority's understanding of its legal task of what it should be doing, and that it was always open to the tribunal at this stage, post-certification but pre-order, to make an order which meant collective proceedings can't go ahead, and it thought that was fully on the table. It was on the cards, they could do that. So this is paragraph 9.
It's the last couple of sentences of paragraph 99, isn't it? Which
It is, absolutely.
an acknowledgement that if it's opt-in, then it's going to grind to a halt, which is simply contrary to the whole ethos of this collective proceedings regime as set out by the majority in Merrick's.
Absolutely, absolutely, my lord. In a sense, there you encapsulate my ground of appeal. It's exactly that the tribunal misunderstood what it could do at this stage of proceedings. Having said that all of the statutory criteria were made out, it could make an order which brought collective proceedings to a standstill. We also have paragraph 118. I think in the light of your lordship's comment, I don't need to take you to that perhaps. Well, your lordships can read it. It may be that the tribunal has an effective choice between opt-in collective proceedings and opt-out collective proceedings, in the sense that both types of proceedings can viably go forward. In such a case, strength of the claims will only preclude opt-out collective proceedings. And then we see at the end of that paragraph, but where opt-in proceedings are theoretical only, in the sense that the reality is the litigation will come to an end unless certification is on the opt-out basis, nevertheless, we see they think that they can exercise their discretion in that way.
Sorry, just give me the paragraph number again.
118.
118. Yeah.
So then if we turn to paragraph 372, which is back in the dispositive section. So it's 372, subpara 2, this is on page 428.
Yes.
And it's in Roman 2 within that. So we're 372, sub 2, Roman 2. And if I might ask your lordships just to read that paragraph to yourselves. We say, frankly, I'm afraid that it's replete with legal error.
Yeah, this is the access to justice point.
It's the access to justice point, absolutely. So access to justice does not, in our judgment, mean that every case should be able to be tried. Access to justice does not mean that just because opt-out proceedings are the only show in town, one has an entitlement to opt-out proceedings. And of course, I say that's wrong. And I'll develop my submissions very shortly on that in due course.
Yeah.
And my final paragraph reference, my lords, is on page 438. Now these paragraphs 383 to 387, are very important for today's purposes and tomorrow's purposes, because this is where we see the majority's findings, their conclusions on the opt-in or opt-out issue. 383 we can ignore for present purposes. 384, likewise for present purposes. 385, they come to access to justice, and they say, well, really, the only thing that's pointing in favour of opt-out proceedings is that we're choosing here, and we see it underlined, it's between opt-out collective proceedings and no proceedings at all. We see that underlined. They squarely look in the face the decision which they're taking. And they say, nevertheless, they're going to make that order which will effectively preclude opt-out proceedings. And in 3851, which is over the page on page 439, again, first sentence, we accept that not certifying on an opt-out basis means that based on the evidence put forward in the applications, the claims articulated by the applicants will not proceed. Ordinarily, that would be a significant factor. Well, yes, one would think it would be a dispositive factor. But in this case, and then we move on to reliance on the strikeout point, which we'll come to in due course, and then practicability, which is zone 2. And so they say, because of those two reasons, strength and practicability, both of which are wrong in any event, in my respectful submission, but we'll come to those in due course. For those reasons, they'll effectively kill the claim. They bring the claim to an end. Then on page 446, the very final order, disposition, part 9, formally under paragraph 411, what they've done is stayed the applications with permission to apply to amend. But of course, it's common ground that no such application would be made, and that's the very premise of the judgment. So I won't labour my submissions because I'm grateful to your lordship for already having summarised the thrust of them. But it's this, I say that the approach demonstrates a clear error of law. In particular, obviously it undercuts one of the core statutory purposes of the collective proceedings regime, namely access to justice. And of course, this court recently had cause to consider and affirm the statements as to statutory purpose that were made by Lord Briggs in Merricks, and of course your lordships reaffirmed and summarised those principles in Le Patorel, have referred back to them in subsequent judgments. Now, it's plainly not facilitative of access to justice to make an order which will prevent access to justice. I know that sounds glib, and I'm sorry for that, but that is my submission. And I also say, if to the extent that this is any different, that there is an entitlement to have the proceedings go ahead as collective proceedings.
If it's arguable.
If it's arguable, of course, if one passes strikeout, absolutely. So we have the very clear description of how the regime works in Merricks, don't we? That once you've passed strikeout, you have an entitlement to have the proceedings brought collectively. And there, I'm going to come on to shortly whether at that point there's also a role for the tribunal in saying go down course A or go down course B, you know, opt out or opt in, but you're going to go down one of those courses that gives functional and effective access to justice. You've passed the hurdles which entitle you to that. And in McLaren, I'm not going to open it up because you're very familiar with it. It's at tab 51, page 1553, para 41. Lord Justice Green, Lord Justice Snowden, on that occasion as part of the court, held this. The Supreme Court in Merricks made emphatically clear that once the CAT has concluded that a claim was arguable and was not to be dismissed on the merits, there was an entitlement or right on the part of the class representative to have the claim tried. Once the strikeout hurdle had been passed, the claimant is entitled to have the court quantify their loss almost ex debito justitiae, paragraph 47 of Lord Briggs. And the right to trial in those circumstances is unavoidable. Again, in Le Patorel, again, I won't turn it up, para 66, page 1244 of the authorities bundle, there would be little point in the CAT certifying a claim on the basis that it facilitated a large-scale consumer claim, which otherwise would not occur, but then ordering it to be opt-in with the consequence that few took up the option and the claim withered away to nothing. So in a sense, that's a lesser version of the high point that we have in my claim. It's also, of course, undermining of the second statutory purpose, the disincentivization of wrongdoing, because we have collective proceedings which otherwise meet the certification criteria, which would constitute a discouragement to anti-competitive conduct, and it's known by those who would engage in that conduct that actually such proceedings, despite the fact that they meet all of the statutory criteria, in fact will not be brought. And we know, because one of the statutory tests is it can these proceedings be brought individually? We know that it's very likely that if those proceedings can't be brought collectively, they will not be brought at all. Mr Lomas's dissenting judgment provides further support on this issue. So if I could just quickly take you to that. So it starts at page 446 of the bundle, which we should have open in any event. And then at page 447, we have the divergence from the majority view. And in paragraph 1, we see immediately Mr Lomas gets this point, that there is a deep tension between determining, even if only by a small margin and whatever the views on pleading or evidence, that an application meets the criteria for certification, thereby enabling the class to have access to a process which will enable their claims to be adjudicated, and then selecting a procedural method which, on the evidence and assumptions, means that adjudication will not in fact occur. That seems to me to be inconsistent with principles of effectiveness and the approach recently taken by the Court of Appeal in Stellantis, and of course refers to paragraphs 26 and 29. I won't take you through the rest of his paragraphs. There's further relevant reference to this, 415 sub 2, 449, 451. And at the end of paragraph 451, he says the satisfaction of access to justice concerns must be real, not notional, and present a viable pathway for PCMs, prospective class members, to have their claims adjudicated. And we say he's entirely right. So my ground...
Can I ask you what his view was on the merits? He seems to endorse the majority's view for need of a more precise pleading. He thinks that a theory of harm was in the process of emerging. So he takes a somewhat more nuanced view of the merits insofar as it feeds into opt-in, opt-out. But he does take the view that the critical issue is, if it's opt-in, the case dies, and that for him is the pivotal or central point. How do you analyse his view on the impact of the merits, of which he takes a slightly more sanguine view than the majority, on the opt-in, opt-out?
So I hate to look as if I'm ducking a question, but I'm quite conscious that Mr Joel has prepared to address strength of the claims. I'm ducking.
That is ducking.
Yeah, it's
I'm
ducking.
But we do see at the beginning of Mr Lomas's dissenting judgment in paragraph 414, he says, oh yes, I did share some of the concerns about pleading, but I do think the pleadings were getting there, and I think that was fine. And then on strength of the claim, very broadly speaking, he thinks, as you said, my lord, he's quite sanguine about it. And he thinks it's a factor that could point, broadly speaking, in either direction, and not a weighty factor in any event, which I may say is in accordance with your judgment in La Paterelle.
You just inserted some words when you didn't duck. You said, and it is fine. He doesn't quite go that far, does he?
This is why I probably shouldn't have said anything. Mr Joel will be shifting in his seat next to me.
Yeah, I mean, he says what he says. I mean, he thinks that the case is emerging. He thinks the pleadings need to be refined. He's obviously more sanguine than the majority. He then says, I'll probably not say any more about it.
He does. And we'll address that in due course. One of the reasons why I have strikeout as a freestanding ground of appeal is that I'm concerned by that risk, quite apart from opt-in, opt-out, and I'm concerned to address...
And if one looks as in what might describe as sort of classical pleading terms, if this were high court litigation as opposed to carrot, you might say that the approach that was adopted by the tribunal was a rather odd one, because normally the court would, if the court was of the view that the current pleading was insufficient and was strikeoutable, if I put it that way, then the court would normally afford an opportunity to amend, give permission to amend, and if for whatever reason the claimant couldn't amend to address the court's concern, they'd strike it out. The judge would strike it out.
Yes.
And I think that's the point that Mr Lomas is making here. In the context of these sorts of cases, there are any number of reasons why the tribunal would take a more sympathetic view, if I can put it that way. And there's a whole point about informational asymmetry or whatever, that arises. But I mean, here you have where the tribunal seems to have got to is saying, well, even though you have provided us with additional material, you still haven't given us enough. But we're not going to strike this out. So were this case ever to go on, which of course it won't because we say it's opt-in, then you would have an opportunity to make things better. So it's a very, I have to say, I thought it was a rather odd approach to the issues they had to decide.
Yes, my lord, and I know that Mr. Joel will.
It maybe just said it's a premature view to say we're going to permit a pleading to occur in the future, and not to wait for it if you take the view that merits are relevant to opt in or opt out.
Yeah.
If it's irrelevant, then it doesn't really matter what you do. You just decide opt in or opt out. But they took the view it was relevant.
Yes.
Then the question is, why didn't they wait?
Why didn't they wait? Absolutely, but
And strength must mean something to do with the strength of the claim. So it's even sort of odder approach really.
It is not just the strength, it is when you see a fuller pleading, you begin to understand how, and they were obviously concerned from a case management perspective of how this would play out. They couldn't see how this would be case managed. But if you have a fuller pleading, even if you're not looking at the intrinsic merits and you're trying to work out on an opt-in, opt-out choice, which choice gives you the best ability to manage the process,
yes,
you might still wait.
that's true. From in terms of opt-in, opt-out, and the overlay between that and case management, it's likely only to be the extent to which disclosure is needed. I suppose it's difficult
we see
to
that.
see.
I mean, we're talking really in theory that how many ways can merits be relevant to opt in, opt out? In some respects, the intrinsic merits are a constant, regardless of whether it's opt in or opt out. Could they then have an impact on case management? Possibly.
Possibly, but not.
But if you do take the view that merits are going to be relevant or might be relevant, then you might think, well, we'll wait and see what the new pleading is going to look like.
Quite, my lord, and I know that one of the things which Mr. Joel is going to address is the procedural unfairness of how everything unravelled and the incoherence, if I can put it that way, I'm sorry it's very disrespectful, of the various different findings, saying that it wouldn't be struck out, that we would be given another opportunity, and yet saying, as you'll see, as part of the key reasons for taking the approach that they did, that there's no reason to allow a claim that displays no reasonable prospects of success to proceed. That's why they were comfortable with bringing the claim to an end, and we do say that was incoherent and unfair. We do say that the claims are well pleaded and sufficiently well pleaded in any event, and you'll have seen, or you'll see in due course when I take you through my pleading, that we plead by reference to the expert report, which is in a sense unconventional, of course, in traditional private pleadings. But in this regime, where we put in an expert report at the same time as putting in our claim form, we naturally cross-refer to it, and I'll be taking you through that expert report. And we also, of course, both provided further and better particulars over the long vacation. So but by the end of the long process, I think we both felt that we had very clearly articulated the theories of harm and how they would be tried. There was also a teaching, and I'll be taking you to some of that in due course. I know Mr. Joel will as well, or I suspect he will be, in which those questions were put to our experts. My expert, Professor Rhymes, said, oh, well, I'd have disclosure of the chats, and then I'd look for correlation in the transaction data, and there would be a regression analysis performed by Mr. Ramirez. That's for my side. There'll be similar for Mr. Joel's side. So I have to say that I don't accept the premise for the question, but I otherwise agree that it is an odd approach.
Can I just, I mean, it may be Mr. Joel later on, but the tribunal had before it quite a lot to do with Essex and bananas.
Yeah.
But it didn't have lads.
It didn't have the lads, no.
And lads is of a different level of detail.
It's fantastic.
And actually provides much more an analytical approach to how the spreads operated and potential impact.
Absolutely. That materially changes the merits assessment in any event. And I'm sure that's the point that Mr. Joel will be making. If not, it's one that I'll be making after him.
No one's really pleaded, lads, but maybe...
No, we will do. Well, yeah, if we live to fight another day, which at the moment we're dead, so we're not trying to do anything. But if your lordships were to overturn the order, grant the order on an opt-out basis, we would be applying to amend and introduce
to know analytically, forensically, how far the lads go with you. Where does it end up? Because it's not a traditional object analysis, it is based upon the evidence, and the Commission makes some conclusions about effects or probable effects or systemic effects. We'd be interested in how you analyse them. And also as to what conclusions they arrive at, both in terms of gain to defendants, but also then consequential losses to counterparties. We're also interested in what's meant by damages in an aggregate case such as this, whether, to what extent at the end of the day the court would need causation from gain into losses for trading partners, or in aggregate damages cases, is there a concept of disgorgement, counter profits, tortious Rotham Park? Anyway, these are matters which we were just struck by the fact that the tribunal didn't have the lads before them.
No, absolutely.
And that might have been relevant because the difference in detail between the lads and bananas and just general geographical ethics.
Absolutely. I will address all of those points. I will seek to address them later today. I hope that those sitting behind me are frantically writing notes on them. But in general, we would say at the very least, the Sterling Lads decision contains very significantly developed information about how the market works. And the thrust of many of the questions which were put to us in closing below when this emerged were questions about the market. Very basic questions, why would spreads have widened? And you'll have seen in Sterling Lads, or you will be shown in due course, that there are paragraphs addressing why it is that dealers who feel things are going wrong for them on the interdealer market, they think, gosh, I'm losing a lot.
Well,
they
we read
respond
Sterling
by
Lads
going
more closely than we read the other decisions.
Yeah.
That's very helpful, thank you. I'm going to crack on with my ground one, if I may, but that's extremely useful. Thank you, my lord. Now, I'll try and take this relatively quickly, because I am, of course, mindful that you're likely to be against me on this, but I say I'm afraid that I'm right. So my ground one is that the tribunal erred in law in finding that it had the discretion to consider whether to make a CPO on an opt-in or opt-out basis where neither applicant sought certification on that basis. And I'll open up the regime shortly to the extent that I need to, but the reason I say that I think I'm right as a matter of law, that there is no such discretion, is that I say it's the bolt-on of an additional step after satisfaction of all of the statutory criteria, all of the merits criteria for certification. And I say that step is disruptive of the certification process. I say it's dissonant with it because it automatically pulls in merits when the one thing we've been told really clearly is don't think about merits now. And I also say that I see very little purpose to it. So I see enormous disbenefit and very little benefit. And the reason I see very little benefit is this. If the discretion is properly applied, it won't change anything. That's because if I have, say, 50 class members, all of whom have a very significant potential claim, a claim in the many tens of millions, and I have a list of them, I can contact them, I can email them, then if I bring that as an opt-out, under the regime, I have to email them, I have to contact them anyway. I'm made to do that under the opt-out regime as part of notification. I have to have a notice and administration plan, and each of those will come forward in the opt-out proceedings and claim their distribution of damages at the back end anyway. They'll function in that opt-in sense. Or if they're in an opt-in proceedings, obviously I have to go out and sign them up. It's much more expensive. There's more of a hurdle because we know, and I think this court acknowledged this in La Paterelle, it's much more difficult to get people to sign up at the beginning than at the end. But fundamentally, there's no greater exposure for the banks, for that group, a prime opt-in case, if I can put it that way. There's no greater exposure if they were brought as an opt-out proceedings. And so this idea of leverage, which we see articulated in the dissenting judgments of Lords Leggett and Lord Sales, which depends entirely on the existence of undistributed damages, that doesn't exist in an opt-out case where the opt-out case in fact should have been brought as an opt-in case. I don't know if I've gone too quickly with that point, or if I've gone too quickly.
No, you haven't. No. Understand the point.
Your Lordship sees the point. So if this function is exercised correctly, it serves no purpose, or it certainly, I don't know the purpose it would serve, and it certainly doesn't serve the purpose which the tribunal thought it would serve. Because those claims with significant undistributed damages at the end, they can never be brought as opt-ins. Obviously they couldn't be. Because if people aren't going to come forward at the end to collect their free money, they're certainly not going to opt in at the beginning. So I don't understand the purpose of it. The other reason why I wanted just to direct you to these relevant paragraphs in the tribunal's decision is because I think, again, they're full of error, I'm afraid, in their approach. And I think they may provide a useful example of how wrong it goes if the tribunal understands that it is in general possessed of this discretion. So, starting with the statute, which I can address very quickly, but we have in Authorities Volume 1, Tab 2, page 5, and this is just to refresh your memories. You'll know this in any event. But in the statutory regime, in the primary legislation, we have two conditions for certification: eligibility of the claims and authorisation of the PCR. And we see set out in section 47B a clear and prescriptive list of what has to be fulfilled in order to go ahead as collective proceedings. And we know that in our case, those were all held to be fulfilled, and the tribunal had indicated that it would certify both applications. There's no reference at all on the face of section 47B to also needing to satisfy the tribunal one way or the other, or the tribunal itself needing to exercise this discretion. All we see in section 47B is in subsection 7, a collective proceedings order must include the following matters. Now, of course, the CPO is a really important document. That's the thing that's on all our websites. It's sent out to everyone. It's the constitutional document. And we see authorisation of the PCR, the description of the class, extremely important, and specification of the proceedings as opt-in or opt-out. And again, of course, a core piece of information to convey to the class. I say that that language, specification, cannot be read as indicating that at the point of making the CPO, a tribunal could at that moment say, oh, opt-in or opt-out. And indeed, when this point was raised below, in front of the tribunal, it accepted that it couldn't mean that, because you'll have seen it has to stay the applications. We've only made applications for opt-out proceedings. It has to stay them and allow us to make fresh applications on an opt-in basis with, for example, a brand new funding package yet to be conceived of. It's not going to happen anyway for all the reasons we've set out. It can't do this specification thing at that moment of the CPO. In fact, what it's purporting to exercise is a discretion which arises at an unknown moment, at some point between satisfaction of the conditions in 1 to 6 and making of the order in 7. We don't see it anywhere on the face.
So you say that if you only apply on an opt-out basis, if the criteria in section 47B 1 to 6 are satisfied, the tribunal has to make an opt-out collective proceedings order.
I do, my lord.
It can't say, well, we don't think opt-out is suitable, and stay it and leave it to you as to whether you choose to bring a separate opt-in application.
Absolutely, my lord. That's my position, yeah. But there's a clear regime. That's the output. We have an entitlement to go ahead on that basis.
Well, I suppose because what we said against you is that enables the class representative to effectively dictate that there should always be opt-out, but the answer to that may be, well, if the defendants want to contest that and say, well, actually this shouldn't be opt-out at all, it should be opt-in, then of course that issue would then be before the tribunal, which would have to resolve it.
Well,
Even
no.
if you'd only asked for an opt-out order, if the defendant says, oh, no, not suitable at all, but if it is suitable, it's only suitable for opt-in, then that would be an issue that was before the CAT.
Your analysis.
Your
My analysis,
complaint,
no. My analysis, no, because that's exactly how this point
well,
arises.
that's why I raised that point.
Yes,
I mean, I
very
understand
good point, my lord. Yeah.
that you say here, nobody actually asked for opt-in.
The defendants did. The respondent bank said that it should be opt-in.
Right.
But you say that's irrelevant.
I say that's irrelevant. I do.
Well, I think that's pretty odd. But anyway, there we are. That's your submission.
That is my submission.
Even if legally correct and elegant, it's still pretty odd.
It's not odd, my lord, in my submission, because we have a regime which has these twin statutory purposes. We know what they are, and we have it set out in primary legislation what are the tests that need to be met in order for those proceedings to go ahead. And it is very odd indeed if there is in fact a very significant part of the certification process that completely passed Parliament by, that completely passed the Supreme Court by in Merricks, and we see now that in these CPO applications, the very things which were prohibited by Lord Briggs in his judgment are the things which we're now arguing about. And also, as I sought to explain in opening this point, if one understands properly what's meant by claims suitable for opt-in proceedings, it's not even a useful point. It's not a useful exercise to determine.
If there's no jurisdiction, why does the order have to include the specification in 47B7C?
The order has to include it
I
because
know it has to include it, but why?
so that the class members know what they have to do.
Well, but it doesn't need to appear in the order if you're right.
Well, the order is the document which is constitutive of the proceedings.
Yeah, you say what your proceedings are, you say they're opt-in or opt-out, and the court says either yes, you can go ahead with them, or no, you can't, on your analysis. There's no reason for the court to have to quote specify in the order at all.
But it is the court's order or the tribunal's order that is the most important document. It's that document to which the class will go. And were that order not to specify opt-in or opt-out, the class, busy people as they doubtless are, would look at the key document and wouldn't see what they needed to know to see on it, and would have to ferret through our submissions. They'd probably be online because most of these things are published, but they wouldn't know that critical piece of information. It just shows how important it is, and it is important in my submission.
And this doesn't address Rule 79.3 at all, does it? This point?
It doesn't. I'll come there very shortly. I've got my eye on the clock, so I'm going to have to whiz through this a little. I was going to take you to the Patterell, but I'm going to zoom through that because you're extremely familiar with that. And I'm going to go to the tribunal's judgment on page 275. Bundle, tab 14, I'm grateful, page 275. Now, the tribunal addresses here an approach from principle, so we're in the context of it considering this argument which I advanced below. It says it doesn't need to address it because it was against me on the statute. I should have taken you to that earlier, but in paragraph 82 above, we'll see that they say that there's no implied limit on the tribunal's discretion in section 47B4. And section 47B4 is that the collective proceedings may only go ahead if the tribunal makes an order. So it's placing heavy reliance on that word may, and I say more reliance than it can bear. It then turns to an approach from principle, so it doesn't need to consider purposive construction if it's considered the black letter of the statute. I say that's wrong, that one always needs to look at the purpose of the statute. Para 87, it says that the PCR will always prefer opt-out to opt-in. We say that's not the case.
Sorry, did I somewhere miss your answer to the point made in paragraph 84?
No, I'm coming to that after statutory purpose, if I may.
Okay.
So 87, PCR will always prefer opt-out to opt-in. We say that's not the case. I referred earlier in one of my answers to Lord Justice Green to obviously the availability of disclosure, the ease of taking instructions from the class and so on, but also, of course, speaking entirely crudely but realistically, in terms of how funding works, if one is not going to have undistributed damages at the end of the claim, one can't bring it on an opt-out basis, sensibly, because that's how the claims are funded. So if there is a claim where you have your class of 50 people, they're all going to come forward, they're super eager, there's no way you could bring it as an opt-out anyway. The application would be for an opt-in, because that's the only viable funding model. Paragraph 88 refers to the distinction between the interests of the due administration of justice compared to the class and the defendants, and that the position of the PCR is irrelevant. I'll come back to that shortly when I address practicability. In para 88.1, the due administration of justice is set out by Lord Sales and Lord Leggett. We of course agree that that part of the judgment is consistent with the majority in merits, but I'm afraid that in the words that follow, we see a glimpse of the error that we then see developed through the judgment, in particular when we get to practicability, which is the view that opt-out proceedings require some particular justification. And in this paragraph, it's put rather low, just their unusual nature, and that requires justification. 88.2, of course, the victims are at the heart of the regime, but I disagree, and again, I'll come on to this in due course when I address practicability, that the tribunal should focus on the views of the class members, the presumed views, in relation to which, as we know, even were that to be the sole relevant criterion, that there will be no evidence. And then 88 sub 3, and the reason I take you through all of this, my lords, really is in particular for this passage in 88 sub 3, at pages 278 to 281. And we see the position of the potential defendants developed at length. So this is by reference to the dissenting judgment of Lord Sales and Lord Leggett in Merricks, the bit which the majority didn't agree with, I say, because this was a core limb of Lord Sales and Lord Leggett's view that the tribunal should exercise a more intrusive gatekeeper function, and that obviously is not the basis of Lord Briggs's judgment for the majority. And we see here a description of exactly that sort of leverage risk which I referred to when I was opening this ground of appeal. And I say this is just nothing to the point. Mr. Lomas says in his...
Actually inconsistent with the majority. I mean, the majority have set a relatively low threshold, procedural threshold, but they didn't say that the CAT shouldn't closely case manage cases to ensure that they weren't going to be abused or just purely and simply for the benefit of the funders.
So, my lord, it is inconsistent with the judgment on a narrow question before the Supreme Court. But of course, I can see that some of the justification for the approach taken by this court in McLaren in relation to ongoing case management of collective proceedings in general relate to the need to ensure that, well, cases are managed proportionately. One doesn't really need a new principle for that. It's pretty standard in a way.
So what is it in Lord Sales and Lord Leggett's analysis that you particularly object to?
So this was in the part of the judgment where their lordships were considering the correct approach to certification, on which of course there is a divergence between the minority and the majority. And one of the reasons why the minority said that a stricter approach was needed to certification was because of this risk for the defendant side. So it's really baked into their view of the world, which the majority disagreed with. And I do so for the reasons I've already referred to, that this is totally misplaced, this risk, once you understand the nature of the opt-in class and how they would behave if proceedings were to be brought on an opt-out basis. You have that point. Now I come to rule 79.3. which is the point which your Lordship has put to me. Now, we have this in Authorities Volume 1, tab 5, page 53. Page 52, sorry, that's a dud reference. And so Rule 79, where in the part of the tribunal's decision-making in relation to certification that relates to eligibility of the claims, and in 3, we have in determining whether collective proceedings should be opt-in or opt-out proceedings, the tribunal may take into account. Then we see all matters it thinks fit, including the following matters additional to those set out in paragraph 2. A, the strength of the claims, and B, whether it's practicable for the proceedings to be brought as opt-in collective proceedings, having regard to all the circumstances, including, of course, the estimated amount of damages that individual class members can recover. Now, the words in determining whether obviously tell us that sometimes the tribunal has to do that, but they don't tell us when the tribunal needs to do that. So we see that same language used throughout the rules. We see it used in the previous subsection, 79 sub 2, in determining whether the claims are suitable to be brought in collective proceedings. But that, of course, is referring back to part of the statutory test. So we know why and when the tribunal is asking itself that question, and this is just telling the tribunal how it does it. Similarly, in the previous rule, Rule 78, sub 3, we have in determining whether the proposed class rep would act fairly and adequately in the interest of the class members. We know why the tribunal is asking itself that question. It's in the primary legislation. This is telling us how the tribunal should exercise that discretion. Again, 78.2, in determining whether just and reasonable. And again, we find that in the primary legislation. So what we see here is a reference to in determining whether that tells us sometimes it must be doing it, but it's discordant with the rest of it because it doesn't otherwise slot into the regime. Further, we see that in a sense it's additive. And we see it's additive because one applies 79.1 and 2, and then one applies the same considerations again as part of this process with the additional 2 criteria. So I say this, that it only sensibly works if you've already considered that application applying those criteria, 79.2 in the first place, taking you to a certain moment, and then you conduct the additional analysis which would arise only in a case in which there is an application on both an opt-out and an opt-in basis. And it's just telling the tribunal, in that case, like in the UKTC application, how the tribunal is to exercise that discretion. Otherwise, one has this position. I put in a very, very detailed application for proceedings to go forward on an opt-out basis. It goes through all of these little gateways, all of these little tests. We get to the end of it, we've satisfied it, and then for the first time, a phantom, hypothetical opt-in set of proceedings arises next to me. It doesn't have a funding package. It doesn't have a notice and administration plan. It may not even have a PCR. If my PCR thinks he doesn't particularly want to represent 50 big banks and no one else. And for the first time, at the end of this very lengthy and important process, up it pops. And it's treated as additive, whereas in fact, one would sensibly have to go right back to the very beginning, ask oneself Rule 78, ask oneself Rule 79, and then only then get to 79.3. So it only works in the rules if I've applied on a dual basis. So those are my submissions.
You may be saying no more than in the vast majority of cases, I think this may actually come from the 2015 Bayes report, that opt-in doesn't work.
Of course.
And therefore the discretion might be strongly tilted in favour of opt-out. But what you're saying is, for those reasons you've just given, opt-in doesn't often work.
It doesn't work.
But that might just be the way the discretion should be exercised, as opposed to there being a fixed rule.
It It may be, my lord, it may be that if there is a discretion, it should be exercised only very seldom, and it shouldn't be a routine point that's always taken. But I do say one can go further and say there isn't the discretion, there doesn't need to be one, and it's extremely confusing, and perhaps one of the reasons that the tribunal got itself into a bit of a pickle, if I might put it that way, is because it thought that it had to ask itself a question which it didn't have to ask itself.
So do you say that Rule 79.3 is ultra-vires?
No, I don't say it's ultra-vires. I say it arises if I were to apply on a split basis. So in the trucks litigation, UKTC applied for opt-out and opt-in the alternative, as I understand it. And if I were to make that sort of application, it indicates to the tribunal the sorts of considerations that unusually are on the table. Because, of course, normally the tribunal can't consider strength of the claims. That's totally forbidden. I say arises only then. It's a very peripheral power, and it should not have assumed the importance in the cases that it currently has. So those are my submissions on my ground one. Ground 4 concerns practicability. If I could ask your lordships to turn up the judgment again, Core Bundle 2, tab 14. And if I might just start by setting the scene a little, paragraph 93, page 283.
Yeah.
And this is where the tribunal is directing itself in relation to the factors which it's going to take into account.
Yep.
Just by way of scene setting here, because it sets up some of the legal errors that we see coming through later. Paragraph 94, we see the tribunal, is on page 283, the tribunal referring back to that dissenting judgment of Lords Sales and Leggett, that opt-out collective proceedings are unusual, normally they would be abusive, they can't be stigmatised in this case, but they need to be ordered in the appropriate case. 95, what then is an appropriate case? And the tribunal, over the next sub-paragraphs, sets essentially up a hierarchy, starting with claiming individually, then claiming in opt-in proceedings, and then in sub-paragraph 5, finally arriving at opt-out proceedings. And it's very obvious, and of course the tribunal didn't have the benefit of your lordship's judgment in Le Paterel, but it's very obvious that the tribunal is setting up what it perceives to be a hierarchy from normal, a bit odd, to very odd, and something which you should only let go ahead if it really makes sense. And I say, of course, that that's flatly contrary to the judgment of Le Paterel, which the tribunal didn't have the benefit of, that the regime is neutral as between opt-in and opt-out. I also say it's contrary to the point just made by my Lord Justice Green, that whilst the regime is neutral as between the two, very often it will only be the opt-out claim which allows effective vindication of rights and the disincentivization.
Well, that's certainly true in the case of the where the individual claims are extremely small ones. So, merits is a sort of classic. So was Le Paterel and Gutman, both. Well, the individual claimants would be looking at £37 or whatever as their claim.
Yes.
Disincentive to opt in if you're only going to get that at the end of the day. And that's the point that you made.
Absolutely, my
But
lord.
it's said against you. Well, here the individual claims could be as much as £63,000 or whatever.
I'll turn shortly to the numbers. It is, of course, the case that the higher value the claim...
Maybe that's trucks where it says 63,000.
No, it's the judgment, but it's the wrong number. It should be 3,000, but they use 64. But I'll take you to that shortly. It is, of course, the case that the bigger the likely claim, the more likely it may be for a person to opt in. That's, of course, true. It's nevertheless the case that there is an enormous and readily observable default effect, inertia, failure to come forward, even at the end of collective proceedings, when one simply has to put one's hand up
Well,
and
there's a
get the
perfectly
free
valid
money.
point that even if it's £60,000, look at this appeal. Are people really going to want to get themselves embroiled in litigation of this kind?
Absolutely.
The hourly rate in this room is probably 60,000.
Say more about your days at the bar,
That's
maybe.
modest.
every 5 minutes.
Yes, my lord, of course. So engaging in litigation is enormously unattractive, and I'll take you to Mr. Mayton's witness statement in that regard, when he spoke to the people with the very highest claims in this group. And I will be saying that it's a heterogeneous group, it's a diverse class, and one of the many, I'm afraid, things that the tribunal did wrong was to lump them all together into one pot, to use a single average claim, to treat them monolithically. That was wrong in itself. But even if one were to try and hive off just the very highest value claims and ignore the tens of thousands of low value claims, even for those highest claims, the cost-benefit analysis does not work. They don't want to do it. They don't want to come forward. That does not mean that if we were to successfully litigate their claims and that amount of money were to be available at the end of it, they would not come forward. That's not the same question, and I know that your lordships have acknowledged that in other judgments.
I think I've seen some statistics which suggest that the highest percentage recovery in class actions, but here, US and Canada, is 60%.
That's about right. Yeah, that's about right. So even then, people don't
That's
always
top
come
end,
forward.
yes,
That's top end.
Yeah.
That's top end. Paragraph 96, just so you have this word, the word is buy-in. So the tribunal essentially directs itself that the key question is buy-in from the class, and that in opt-in proceedings one has buy-in, and in opt-out proceedings one may not have buy-in. And so the two additional factors in the rules must be important in determining whether certification of collective proceedings without buy-in of the relevant class members can be justified. And we see that word coming through the rest of the judgment. Mr. Lomas, in paragraph 415 sub 3, which is on page 448, says claimant commitment and buy-in to a case has clear policy benefits. It's the traditional position under English law. However, the CRA 2015 consciously introduced a process without such buy-in to reflect other policy considerations. It was foreseen at the time, and indeed part of the policy objective, that opt-out claims could be initiated by lawyers and PCRs who are not class members, and that those claims could be litigation funded. Those arrangements are permitted by the tribunal rules, and many of the legitimate concerns of the majority seem to me to be inherent in any such opt-out process and are not specific to this case. Our role is to apply the rules, and our discretion is set out below, accepting the fact that statute has indeed introduced such a process, whilst of course being alert to control improper use. And we say it's entirely right to say that this fixation with the idea of buy-in is dissonant with the choices that were made by Parliament. It is in fact reminiscent of the debates in the floor of the House of Commons when the spectre was raised of US-style litigation and everything else. Those arguments were had amongst parliamentarians, a view was formed, and we have the Act. Ground 4 then. Practicable for the proceedings to be brought as opt-in collective proceedings. So that's the language of Rule 79.3 sub B. And we say that the majority of the CAT erred in law in its interpretation of and application of that phrase. Now, of course, in Le Paterel, you considered this in detail. I'm not going to take you through Le Paterel, you're very familiar with it, and I don't have enough time to do so.
But your short answer is the common ground fact on behalf of the tribunal that opt-in is not viable is dispositive.
I say that is independently dispositive, that ground of appeal, absolutely.
That deals with practically. It is, if you decide that it won't happen, subjectively, objectively, man on the Clapham omnibus, whatever, but if the fact finding is it won't happen, then it can't be practical.
That leads, absolutely, that's not practical.
It can't be an answer to say, oh well, this is all because people don't want to litigate in the present case, because that was the whole point in those small claim cases like the Patrol and Goodman, that people would just think it wasn't worth the candle. Now, what their motive was for not litigating is neither here nor there.
Absolutely, my lord.
It's just the practicability of it. It was completely impractical to.
And interestingly, that was the point which both Lord Leggett made in Lloyd and Google.
It was, absolutely.
About convertibility.
Convertibility. It's convertibility, absolutely. Practical, real world, viable convertibility. Are they actually going to go ahead? And so in that sense,
That's it really, isn't it?
that is it. That is it. There are other errors in the treatment of practicability, not least the claim value, the number in the class, Mr. Mayton's evidence on why people don't opt in or opt out, but you have the core reason why I say I should
You've got
win.
a finding of fact which takes into account all those matters. It won't happen.
Absolutely.
It doesn't matter what the numbers are, either numerically in terms of the claim or the reasons why they don't. It's common ground that it won't.
It's common ground that it won't. That's right. So that's why I have it as a separate ground of appeal. Were you to have been against me on that, were you to be against me on that principal submission, there are a panoply of other errors in relation to practicability. I will take them very shortly in the light of that exchange. I should probably make them in any event, not to count my chickens, as it were. So I'm not going to take you through Le Patorel. You're well aware of your judgment in that case. The judgment of the tribunal, as we've seen before, is in these two sections. Legal section of the judgment, page 293. So we're in the opt-in, opt-out issue, and this is where the tribunal is directing itself as to the correct approach, and of course it didn't have the benefit of Le Patorel. So 121, it essentially directs itself completely wrongly in my submission, that essentially where proceedings are practicable on an opt-in basis, that should automatically be the order. So it says, of course, we don't consider that those words oblige being underlined, the tribunal, whenever opt-in proceedings are practicable to resolve the opt-in, opt-out issue in this way. But then they explain it by saying, well, first of all, there's a discretion, so that has to mean something, I suppose. And then secondly, they could be practicable, but nevertheless extremely onerous when compared to the opt-out alternatives. So were it not for those two observations, it's pretty clear that the tribunal was taking the view that if opt-in proceedings are practicable, then that is the way they should be brought. The opening words of paragraph 122, what if of the converse case, where it's not practicable for the proceedings to be brought as opt-in proceedings, where opt-in collective proceedings are not possible in practice? As to this, the first subparagraph, I'm afraid I struggle with a little. It's said here that if practicability were to be assessed in the abstract, it would always be satisfied. It says, we have little doubt that any collective proceedings are theoretically capable of being brought as opt-in collective proceedings. I'm afraid I just don't understand that. It's just plainly not the case. One can think of extreme cases like Merrick's by way of example, but it's obviously wrong. Paragraph 122 sub 2.
Presumably agree with that paragraph, that theoretical practicability isn't the test.
I agree with that. Of course, I then say that what the tribunal went on to apply was theoretical practicability. Subparagraph 2, practicable for whom? And we see that's underlined, and we see similar underlining in subparagraph 4 at the bottom of this page. And when we see it's from the standpoint of the members of the class concerned, and it's not from the standpoint of the applicant seeking the CPO. Now, I say that that's a false dichotomy. Of course, it's the case that collective proceedings exist in order to vindicate the rights of the class members and not for the benefit of the PCR. Of course, that's right. Equally, the class members need a vehicle You know, they need proceedings to actually get them where they need to be. And if the evidence is the proceedings aren't going to exist, it makes precious little difference that they would theoretically be practicable. And then we see, again in para 122 sub 2, another underlining, this time of the word why. You have to give due weight to the fact that the reason why members of the class are not opting in needs to be taken into account. And we see again in subparagraph 3 on that same page, a re-emergence of that word buy-in that we see everywhere in the judgment, then halfway through the subparagraph, underlined again, why the putative members of the class are not willing to step forward and opt in. And I say that's utterly wrong, that's a misdirection in law, that's not the right test. It's not the right test that you have to go around trying to identify suitably concrete barriers which one might personally empathise with as a reason not to do a thing. That's not the case at all. It's also impossible to determine.
You say it's not why, it's whether.
It's whether, absolutely, my lord. That's a very good way of putting it. I would gratefully adopt that. It's not why, it's whether. And I say it's entirely speculative as an exercise, and I'll get there shortly. Mr. Lomas, in his dissent, paragraph 415 sub 6. Which is on page 449, says that the approach of the majority on practicability is mistaken. The rule simply means what it says. The tribunal should weigh the objective practicability of the claim proceeding on an opt-in basis. And what the implication for the proceedings would be, as I do below. There's no need, either on an objective or a subjective approach, to seek to assess the motives of a putative PCM in doing so. There's very little evidence on those motives, and it is indeed, as the judgment recognises, an exercise in speculation. The tribunal should be cautious in giving weight to the idea that the unwillingness of the PCM to opt in is a negative measure of its merits, or the PCM's views of the merits, and therefore that the additional benefits of opt-out proceedings ought not to be conferred. And he says as well, we say entirely rightly, that you don't solve that problem by referring to a man on the Clapham omnibus. It doesn't make the inquiry any easier to resolve. So we say he's entirely right. Going back to the legal directions of the majority, so I have my finger at page 294. So again, we have in 5 addressing how they propose to go about seeking to divine the motivation of the class, while saying there will be silence from the class. We don't want evidence from them. And obviously we'll see in due course treating the evidence that they had from us on our engagements with the high value class members with a long spoon. And then in 6, correctly, the tribunal acknowledges and directs itself that in some claims the class may be diverse, the claims are very different sizes, and correctly acknowledges that that should mean that one takes account of the position of the low value people and doesn't shut them out from justice because of the position of the higher value people. But then unfortunately, when we get to the application of that legal test in our case, it's nowhere to be found. It's nowhere to be found, and that is an error of law. So turning to the application in our case, page 432, paras 3, 7, 6 and onwards. So the tribunal refreshes its memory as to the legal directions which it's given itself. And we see in para 377 that the test is not how else could these proceedings be brought, but it requires consideration of why the more obvious route to access to justice is not being taken. So again, we see preference in favour of opt-in, distrust towards opt-out. And then we see the positing of this idea that if it's clear that the putative class just doesn't want to bring proceedings, then the issue should not be forced and proceedings should not go forward when the claimant class has evinced no desire to access justice. Now that conflates two different worlds, doesn't it? So imagine a world in which genuinely all class members had been contacted and they genuinely had all said, I really desperately don't want you to bring these proceedings. I'm not interested in them at all. I don't want you to do it. Well, first of all, there are various stages in the proceedings in which those views could be expressed. Class members can come along to the CPO hearing, they can come along to the first CMC, but they have to be notified in relation to both of those. They can make those views known, and one can imagine in a case in which that were hypothetically to arise, it's kind of inconceivable, but the tribunal, of course, would take into account a clear expression of all class members that they do not want to litigate at all. That's really cloud cuckoo land, I'm afraid. I just can't see that happening. But if that were to happen, that's the way it would be addressed.
Well, they do it with their feet at distribution, I suppose.
Yes, or they'd opt out, or yeah. I mean, there are so many stages in the regime for people to get out if they don't want to be part of it. The second part of the sentence is a different test. It's not a desire to keep your shows in action unactivated and just keep it to yourself and never be recompensed in damages for the loss which you've suffered. Instead, it's where the claimant class has evinced no desire to access justice. So what the tribunal seems to be asking itself now is, show me that you're interested. Now that is flatly contradictory to the opt-out regime and the reason why we have it. It can't be that that is the right test, and it isn't. Turning to paragraph 381, I'm going to come back to paragraphs 378, 380, that's Mr. Mayton's evidence, and I'll turn to that when I address the higher value claims. Here we're dealing with the evidence of my expert economist, our expert economist, Mr. Ramirez, who gave evidence on the likely class size. We see it's a significantly large class, 42,000. It may ultimately be very much bigger, it may be 100,000 once you put in the very lowest value non-financial institutions. So that's point one in favour of impracticability. It's a massive class. We also don't have a list of them. We don't know who they are. We can't contact them very easily. Again, massive practicability point. But in any event, what we're considering here, principally, is the claim value. And so we see after subparagraph 6, this is on page 435, and it was this, my lord, which you accurately recalled as the average claim value in this case. So if you take the total aggregate damages amount and you just divide it across the class, totally flat, do nothing else, you end up with that. Now that is a thoroughly misleading figure, and it's not the right approach. It's not the approach that correlates with the legal direction which the tribunal purported to give itself in relation to diversity across the class. Now the tribunal had before it better and more individualised evidence, and it was by reference to that evidence that I made my submissions below, Mr. Joel made his submissions below, Mr. Kennelly made his submissions below. I'll take you there now. It's in Ramirez 3, which is in the key documents bundle, volume 3. Tab 50.
50.
Tab 50, key documents, that's page 3080. And it's table 4. And so we see here, there are two sets of columns. So on the very first row, we have financial class members and we have non-financial class members. So that in itself is a core driver of the heterogeneity of the classes here. Then we have financial class members, so that's the smaller banks, investment banks, securities houses, different funds and so on, insurance companies. And then we have non-financial class members. So those are businesses, and it may be thought in due course high net worth individuals, but in particular businesses who do import-export. And some of those businesses are very big and some of them are pretty small. So if we look at non-financial class members, number of employees, 50 to 24 now. Now, just to pause there a second, Mr. Ramirez excluded, trying to take a prudent and conservative approach, he excluded non-financial class members with fewer than 50 employees, but there will be some of them in the class eventually. I'm going to come back to that shortly because the Tribunal acknowledges that. But just using these very conservative figures, we have class members, 18,000 of them, who have an average claim value of £3,409. So total class, 42,000, 18,000 of them have a claim worth £3,000. That same first line, the first row for financial class members, we've done this by reference to turnover, not employees, because of the nature of the business of the financial class members. Turnover of 0 to £499,000. We have 15,684 class members, and they have an average claim value of approaching £16,000. So if you add those two groups together, you have 34,000 class members out of our class of 42,000 with those significantly lower value claims, £16,000 and £3,000. This was the evidence by reference to which the hearing was argued. It's profoundly surprising in that context to see in the judgment a flat average, and we do say that that's an error of law. It obscures the nature of the class. If I turn back to the judgment, we're in paragraph 381. I'm going to jump over 9, which I'll come back to, and subparagraph 10. So this is on page 437. So in this paragraph, the tribunal is considering a further group. So it's really the large penumbra around the class as we've dealt with. In the class, I've got all of those claims of 3,000, all of those claims of 15,000. But there's then another group around the class, a significant group. It could take the class up to 100,000 of small and micro enterprises and high net worth individuals. And the tribunal directs itself, factually accepts that for those, the trading would have been in low volumes if it occurred at all. The claim sizes would have been correspondingly small. It's a much more diverse potential membership. For this group of persons, the merits factors, which is I think what he's using to refer to the purpose of the statutory regime, they apply with more force. The claims will be small. The class members may well not know that they have the claim for the small sum of money in any event. Even if they do know, they may not care. But the tribunal takes the view that that group, 60,000 potential class members, should not alter our conclusions on practicability, because we've reached such firm conclusions in relation to motive. I'm about to go to those conclusions because I don't understand them. And the tribunal concludes that would be to allow the tail to wag the dog. Now, just numerically speaking, it's entirely the other way around. The dog's wagging the tail, as it should be, but it's entirely the other way around. We have the vast bulk of these claims are comparatively low value. In particular, if you're a commercial enterprise, it may be that if you're a consumer...
Well, it takes you, I mean, the question of whether you've got a hold of the tail or the dog depends upon whether you're focusing on numbers or value, doesn't it?
It does, my lord, and I say squarely, it's the claim value in the hand of the class member. What one can't do is have 100,000 class members, each of whom are owed only £50,000, and then say, oh, well, I'm just going to treat it as the total of 50 times 100,000, and that's it, that's all they're worth. You can't do it just by reference to aggregating the claim values and saying that's a small amount of the VOC, it's a small amount of the total quantum.
But it cuts both ways, doesn't it? Because, in a sense, the issue of the practicability of opt-in versus opt-out will be affected by both the things that are identified in subparagraph 10. First of all, the number of them, the fact that there are 60,000 of them, therefore they're by definition, and secondly rather, that they may not even, their claims are very small, may not even know they've got them. So in opt-in terms, where are you going to start? In practicability terms, how are you going to know where to go to?
Absolutely.
Which is one of the points that we made in the two previous Court of Appeal cases.
Absolutely, my lord.
So
absolutely.
they correctly identify that the merit factors apply with great force and then effectively ignore them.
Ignore them. Absolutely ignore them.
Well, they ignore them because they concentrate on the total value of their claims
If you aggregate
rather
them.
than the number of them.
Yes. And I say that's an error of approach, because necessarily when one's thinking about practicability, you're thinking about how likely is it for that person to want to come forward to get that amount of money. So that has to be the right analysis. One can't possibly aggregate lots and lots of small value claims together, say, well, it's not much overall, so we can exclude a huge number of class members. And then the regime only functions for a handful of individuals or of class members who have a high value loss. That's totally distortive. It turns the thing on its head. The core purpose is to litigate for those with lower value claims. That's what the regime is designed for. So I say that again is another error of law, an error of principle.
Yeah.
Finally, before I sit down and allow Mr. Joel his time, I'll turn to the error in relation to Mr. Mayton's evidence and the larger value claims. So if we go back to paragraphs 378 to 380, we see this is on page 433, we see the tribunal there refers to the evidence of Mr. Mayton of Housefeld in relation to the considerable effort which he went into to build a book in relation to the highest value claims.
Sorry, can you give me the reference again?
Sorry, yes, it's page 433 and it's paragraphs 378 to 380. And in paragraph 378, there is an accurate summary of the efforts to which Mr. Mayton went and his team. 321 firms likely to have traded those very highest volumes of FX, 6,000 hours over 4 years. All of this has to be paid for, obviously, and in an opt-in claim, all of these costs have to be funded. There we are. And he ended up, or the firm ended up with only 14 advisory retainers. If I could just take you to Mr. Mayton's evidence, which is in Key Volume 2, tab 29, page 2181. He sets out, this is section A of his witness statement, he sets out the various efforts that have gone to. And then in paragraph 19, which is on page 2186, he sets out his understanding from all of those detailed conversations of the main reasons for the reticence. And in 19A, this is on page 2186, key concern was that they did not want to embark on a legal fight with major banks for what seemed to them a modest to small level of potential damages, in most cases single-digit millions or less. So these are really the very top end of the class, and still to them it doesn't make sense. In particular, many of the organisations maintained ongoing relationships with those banks, including corporates, hedge funds, asset managers who worked in the finance sector, and did not want to take steps that would cause conflict in those relationships. In B, several organisations, including sophisticated financial institutions, expressed a reluctance to invest time navigating their internal approval processes, require obtaining approval from senior managers, considering funding proposals and documents, identifying, retrieving and reviewing the relevant documents. Just pausing there, the respondent banks in this case had made it clear that in an opt-in case they would be seeking disclosure from all of those opt-in entities. It's a significant undertaking. And then all of that, determining whether, the potential benefits of a possible damages payment outweighed the downside of allocating internal resources, And Mr. Mayton was also informed in many of those discussions that committing to litigation could also trigger reporting considerations within many organisations. Many of them were reluctant to draw attention to this issue internally. Then C, many potential claimants expressed concern that participating in litigation would require them to share confidential business information. And of course, it's possible to obtain protective costs orders, such as a confi ring. I was not able to give potential claimants a watertight guarantee in that regard. D, the process of engaging the client itself often proved to be a practical deterrent for potential clients. Many of the 321 organisations and individuals we spoke to told us that gathering historic FX transaction records, along with other relevant evidence to support their claim, would require a significant amount of internal resource. Several told us they no longer retained their relevant records or only had partial records. And for many, this was an unattractive prospect in circumstances where, at that stage, the outcome and quantum of the potential claims were uncertain. And then in paragraph 20, he concludes that that is a cost-benefit assessment. Right? But what it isn't is an expression on the part of those claimants that they are horrified by the idea of the claims going ahead in any form. They're not indicating that sort of motivation or that sort of repugnance or whatever it is that the tribunal thought it needed to look for. I'll take you to the place in the judgment now where we see that. So we've looked at 378, 379, then in 380, the tribunal says, well, this evidence is no more than background, albeit very helpful background, to the question of practicability. It doesn't say very much about practicability from the standpoint of the class. So this is the bind the tribunal's got itself in the first place. It has no evidence about the class apart from this. This is the only evidence it has. It's about the top end of the class, and it has no other basis against which it can possibly measure what it says it's seeking
Paragraph
to measure.
19D is a classic example of why it's impractical. Because you can't get, because you know it's all too much of an effort. We can't find the records. You know, we can't prove our loss.
Absolutely, absolutely, my lord, exactly. And so my final reference before I sit down, you'll be glad to hear, is paragraph 381, subparagraph 9. This is on page 436 of the bundle.
Yeah.
And this is where the tribunal does what on its direction is the core question, it's the determinative question in its mind so far as practicability is concerned. So it can't be said that class members will be ignorant. To the contrary, the efforts of Hausfeld...
Sorry, which paragraph?
This is 9, subparagraph 9 on
Sorry,
page
thank you very
436. I'm sorry.
Thank you.
So we're in 381 sub 9.
Yeah.
So the efforts of Hausfeld, contacting 321 firms, evidence it appears not to be ignorance that's preventing a rush to join the proceedings. Now, just pausing there, there's obviously an enormous difference between those particular firms and all of the rest of the class. Tens and tens of thousands of claimants. There we are. The next sentence, rather there appears to be a deliberate decision not to participate. The word deliberate, I think, carrying an awful lot of weight in that sentence. It's expanded upon as we go through the paragraph. We are conscious that we've not heard directly from any members of the putative classes. No, there's a total absence of evidence. Then there's this sentence which lists various speculations, I'm afraid to say. It may be that putative class members are so unimpressed with the claims that they do not wish to be associated with the actions. Or it may be that those sufficiently interested have joined the Allianz proceedings. Or it may be that the class members are so apprehensive about joining the proceedings because of the potential reaction of the respondents they're deterred from doing so. Or it may be that decision makers simply can't be bothered to consider whether it's in their firm's interest to opt in or not. We have no material on which to base so specific a conclusion. Well, of course, there's the evidence of Mr. Mayton, but otherwise it's because it's a test in relation to which they directed themselves. They won't have any evidence by reference to which they can determine the test.
It would be a bit more difficult in Merrick's when you've got over 40 million potentially.
It would, my lord. We can only say that we can see no reason why it's not practicable for the putative class to join on an opt-in basis, given all the circumstances, and in particular, given the general sophistication of the putative class knowledge and the potential size of claim. Then the inference, and we consider it a strong one, is that potential class members are not opting in because, and here we're underlined again, They do not want to, and not because opt-in proceedings are not practicable. And I say that that is a stark and plain error. There's no basis for reaching that conclusion at all. It applies a totally misconceived legal test in relation to which there's no evidence. And what it does at heart is evince that underlying hostility to opt-out proceedings, which in respect of this vast class, many lower value claims, in relation to them, the tribunal was happy to say, you haven't shown you want it, so you can't have it. Those are my submissions on practicability, my ground 4. Mr. Joel, as I indicated earlier, will sweep up on anything I've missed, subject, of course, to any questions which your lordships may have.
Thank you very much, Ms. Wade.
I'm grateful. Thank you.
May it please your lordships. As you've seen, it's clear from paragraph 385 of the judgment of the majority that the key considerations leading to their conclusion to certify on an opt-in basis rather than an opt-out basis were the two specific factors that are highlighted in Rule 79.3, namely practicability and strength. And the majority held on their interpretation and application of those two factors that they pointed firmly against opt-out and in favour of opt-in. And our grounds of appeal are quite simply that the tribunal erred in both their interpretation and their application of both of those factors, and that on their proper interpretation and application, both practicability and strength firmly point, in fact, inevitably in the case of practicability, point in favour of certification on an opt-out basis. Now, there were other factors that the tribunal refers to and took into account, but as they put it in, I think it's paragraph 384, they describe those as pretty marginal, and they make it very clear that it's strength and practicability that this all turns on. Now, in relation to Ms. Wakefield's submissions, we don't join her in her first ground of appeal, the one that she dealt with second, on jurisdiction. We, for our part, don't challenge the tribunal's finding that it had jurisdiction or power to consider the opt-in, opt-out issue, even if neither of the claimants before it proposed to bring their claims on an opt-in basis. But there is an important distinction between having a power to do something and its lawful exercise. And we say that it was not, in the circumstances of this case, lawful to certify this matter on an opt-in basis, knowing that as such it would not proceed. And we greatly adopt the submissions of my learned friend in relation to her second and fifth ground of appeal, which in many respects overlap with our own second ground. And I'm not going to repeat, of course, what Ms. Wakefield said, and I just want to add a few additional words about practicability before then getting into strength, which is going to occupy really quite a bit of time, I'm afraid, because it is necessary to untie rather a lot of errors in the judgment. Now, we say in relation to practicability that this means, at a bare minimum, whether the proceedings can in practice be brought as such, as opt-in. Are they doable? Now, it also has wider connotations, as recognised by this court in Paterell, but it must at the very least mean that the proceedings are doable. If they can't be brought in practice, then they're not practicable. And Ms. Wakefield has shown you that the CAT accepted that the present proceedings, very probably at least, could not in practice be brought on an opt-in basis. Now, we just say that it's utterly baffling that the tribunal could conclude, on the one hand, that opt-in proceedings couldn't and wouldn't proceed, and yet conclude at the same time that the practicability factor points in favour of opt-in. It's a straightforward contradiction in terms. So how, with respect, did the tribunal get itself into this terrible pickle? And the basic explanation is simple. It made an error of statutory construction. It sought to rewrite the words in Rule 79.3 so that so that it's transformed from its natural meaning of an impersonal, objective perspective into a very different test, which is, would the proceedings be attractive from the perspective of what it called a class member on the Clapham Omnibus, or a reasonable class member. And Ms. Wakefield has shown you that reformulation, which takes place in paragraph 122.2. And I just want to make 3 very basic points about that. First of all, it's not consistent with the language of the statutory instrument. So if I could ask you to take that up, just to have a look at it in full. It's Rule 79.3. It's in the authorities bundle 1, I think. Forgive me. Authorities bundle 1, tab 5. And if you go to page 52.
Yep.
And what it says in 3b is whether it is practicable for the proceedings to be brought as opt-in collective proceedings. And now, first of all, it is framed in the third person, whether it is practicable for the proceedings to be brought. And it is, again, in the passive, to be brought. So that itself strongly suggests that the standpoint is meant to be an objective and impersonal one. And that is reinforced by the words having regard to all the circumstances, because that suggests that all matters are to be taken into account in deciding whether the proceedings can be brought on an opt-in basis, not just some. So the natural language strongly suggests that this is an impersonal approach by reference to all angles and taking into account everything that is required to make an opt-in action happen. Now, the second point I'd make about this, yes.
I'm interested in the way you put your from and to. You say it's from an impersonal objective test to. Would proceedings be attractive from the perspective of the person on the Clapham omnibus? That's
Yes.
what they looked at it.
Yes.
I mean, what is the difference between the two? Because objectively speaking, the person on the Clapham omnibus might take into account all the factors set out in Mr. Mayton's witness statement and say, love to, but afraid it's just not doable.
Well, in a sense, that's right. But I think the difference is this, that the general perspective takes into account the need also to have to the perspective of the PCR and the funders and the lawyers, because they are all necessary for this to happen, if you like. So it's really taking it's not just that it's taking it from...
But you say it's too narrow, it's too narrow an analysis.
It's too narrow.
It's a narrow rule.
Correct. I mean,
Is practical is doable.
doable. Absolutely. I mean, if
you have the proof of the pudding
yes,
is in the eating, there is nobody who wants to take it up. You say.
It's terribly straightforward. And I mean, if one just thinks about it in order, we're here on ordinary
It
language.
also goes back to Mr. Ramirez's point about the other 60,000 unidentified people who could be class members in an opt-out situation, but goodness only knows how you ever track them down in an opt-in scenario.
Well, indeed. But I suppose it could be said, well, opt-in proceedings would be practicable for some. I suppose you might have a circumstance where all sufficient numbers, it would be.
I think obviously in a case like Gutman, it really wasn't practical because you couldn't really identify all the people who'd been on the London South Western Railway for a period of 5 years. I suppose in the Le Patrel it might have been practical because you could have, if you'd got the BT customer records, you could have identified all the people on the BT customer records, gone through the electoral roll or through the census or whatever to find out how old they were, etc.
There were some commercial customers.
There were some commercial customers.
But the point that I'm on is really this: is that even if there were some class members who are willing to opt in, if you don't have sufficient numbers that you can get a PCR willing to act, and you can get a funder, then it's not going to happen for anyone. So even if you take it from the perspective of the class member, it's all interconnected with these other factors. It's a bit like if you said, if you asked, is it practicable for our courts to go entirely paperless? You wouldn't say, oh well, let's look at that only from the perspective of the client. You have to look at it from a technological perspective, from the court's perspective, from the barrister's perspective, from the solicitor's perspective. And indeed from everyone's perspective. But it's not as narrow.
There must be, even if you have a heterogeneous class with a variety of sizes, scales, there'll be a critical mass, which may be a hybrid group.
Yes.
which would enable the funders to say, okay, now it's viable.
That's right. And that critical mass wasn't possible here. And that's what the evidence was of both our evidence and Evans's evidence. And it was
But the
uncontroverted.
striking fact is here, that's what the tribunal found as
Yes.
a fact.
Yes, no, indeed. So it's just simply, it's really just a contradiction in terms, the findings. Now, the third point I would stress is that the tribunal's approach to practicability is also unduly narrow, even from the perspective of the class. And if I could just briefly take you back to page 436 in the bundle with the judgment, at paragraph 381(9). I think Ms. Wakefield's taken you to this already. As the reference to Hausfeld contacting 321 firms, and the suggestion that there was a deliberate decision by some of those not to participate. And they say there, we are conscious that we have not heard directly from any members of the putative classes. Now, in fact, they had heard from they had received evidence from a member of the class, because we put in a witness statement from the class, from a member of the class, and I will come on to that in a second. But what the tribunal seems to be saying here is they don't, if you like, they're voting with their feet. They haven't, in fact, expressed any interest in the group proceedings that Mr. Matten has proposed. And it says, effectively they say, they don't want to, we don't care why they don't want to, and we don't know why they don't want to, but they don't want to because they haven't shown interest. And they give a number of reasons why they might not.
But they don't want to wouldn't actually matter.
No.
Unless it was also they don't want to be opt-out either. They don't want to be part of the class, full stop. So they feel so strongly about this appalling litigation that they're all going to opt out.
Yes.
Now, if there were evidence of that,
yes,
then we wouldn't be here today. That's
yes, absolutely. But what they seem to say is it doesn't matter what the reasons are. And even they say they say, for example, they give reasons. They say they accept it may be that the class members are so apprehensive about joining the proceedings because of the potential reactions of the respondents that they're deterred from doing so. Or it may be that the decision makers simply cannot be bothered to consider whether it is in their firm's interests to opt in or opt out. Now, those two things, essentially, those are fear of retribution or reaction, and inertia. And those are precisely why we have opt-out proceedings to begin with. And I don't need to take you back to Paturel, but I would remind you that in the quote in Paturel in paragraph 72 from Lloyd and Google, one of the very factors that's mentioned is lack of resolve. Now, and that's just what they're describing. And yet they somehow think, well, if it's just lack of resolve, tough, that doesn't matter. Now, I want to show you just that they did have evidence from the class, if I may. And I'll show you, you can see that in the supplemental bundle at volume 2, tab 34. This is a witness statement from Mr. Mitchell, who is on the O'Higgins Advisory Committee. And you see in paragraph 1, top of page 2406, that he is a founder and managing director of an FX trading boutique based in London. And that boutique D Square would be a member of the proposed class. So they did have it. And if one goes forward to paragraphs 18, he describes his experiences in the United States when similar claims were brought and there was a class settlement. And he describes his reticence in paragraphs 18 and 19, even at claiming the amounts that were distributed on an opt-out basis in the United States. And the reason is because of his dependence on the RBS, one of the settling banks in the US, as their prime broker. And he thought that participating even in the collective settlement might compromise their long-standing relationship with RBS. And over the page on paragraphs 21 to 27, again, he explains the many reasons why persons in the financial services industry, dependent on their banks, would be extremely likely to be very reticent of joining an opt-in potential opt-in action. And the same goes, and he goes into some considerable detail about the costs that it would involve, the intrusiveness of the disclosure that it would require at paragraphs 31 to 36. So the tribunal did have evidence from a class member, one who explained in careful detail the very real and practical and commercial obstacles that would exist for many class members if they had to opt in. And in addition, there was also evidence from Mr. O'Higgins, our class representative, who was not a member of the class himself, but he had been in touch with many class members. And he gives, again, I just give you the reference, if I may, for your note. He gives a long explanation, again, of the reasons for reticence, which is it's in volume 2 of the supplemental bundle, tab 32, at page 2383. And I'd invite you to read paragraphs 24 to 25 and 31 to 33. And in addition, Miss Holway, the solicitor for Mr. O'Higgins, gave evidence also of the reasons based upon the experience in the United States, where the claims were found to have an extremely long tail. So and this is actually a real experience of Mr. Ramirez's figures, which is that you had lots and lots of, in fact, rather small claims. And again, for your reference, that's in the electronic version of the supplemental bundle at tab 35 at page 2417.
Mm-hmm.
So
2417.
2417.
That's electronic tab 35.
Tab 35. So there was also evidence from Mr. Perslow, the funder, who said that it would not be likely to be practicable to fund an opt-in action, and that is in tab 33 from paragraph 6 onwards. So we say that the Tribunal Justice, with respect, completely lost sight of the wording and obvious meaning of the practicability provision and the wider purpose of the regime and the evidence before it. And once it's accepted and recognised that opt-in proceedings couldn't and wouldn't proceed, it really followed as night follows day that they were not practicable, and that factor pointed, and decisively pointed, in favour of opt-out. So that's all I wish to say about practicability. Strength. Now, Rule 79.3 stipulates that a tribunal can take into account the strength of a case in deciding whether proceedings should be certified as opt-out or opt-in. And I want to start, if I may, by suggesting how we say the strength factor ought to have been approached in a case like this one. And the proper approach, the basic approach, has been addressed by this court already in outline in Paterell at paragraphs 104 to 108. Yes, it's in bundle 4 of the authorities bundle at tab 44 at page 1256.
Sorry, tab?
Tab 44. And the relevant paragraph is at page 1256.
Irritating, you ask you for the tab reference again.
Tab 44, my lord.
And paragraph?
It's paragraphs 104 to 108.
Yeah.
Now, I will not read out to its authors those paragraphs unless you wish me to. But I would, if I may, attempt a respectful summary. It boils down in my submission to 4 points. First, that in many cases, the CAT may not be able to form a clear view on the merits, such that the factor of strength doesn't feature, other than deciding that the claim passes the summary judgment or strikeout test. Secondly, that in some cases, particularly following an unsuccessful attempt at reverse summary judgment, it said, the CAT may be able to say that a claim is strong, and that may be a factor that favours opt-out. And that would often be the case where the case is a follow-on, where there's already an infringement decision. Thirdly, the court says that the potential complexity of the proceedings, the awareness of the members of the class of the proceedings, and their evaluation of the merits is irrelevant. And fourthly, it says there is no additional merits threshold for opt-out proceedings that needs to be satisfied. There's no sort of higher than strikeout standard to allow you to go for opt-out. The safeguard is the general gatekeeper function of the tribunal. Now, it's not expressly stated there, but I would suggest that it flows from that overall approach, that there is also a fifth principle, if you like, and that is that it's not the job of the tribunal in considering and assessing strength to try and assess and comment on the weakness of a claim. Put another way, it is not appropriate under the rubric of the strength factor for the tribunal to label the claim as weak or very weak and then regard that as a factor for opt-in rather than opt-out. Strength rather is intended to operate in a limited set of circumstances where there's ostensibly it can be said on a high level the claim is strong, and that is potentially, sometimes, not often, a factor in favour of opt-out. Now, we say that in light of that Paturel approach, it's then interesting to consider how the tribunal should have approached strength. And we say there are a number of... Yes.
Why do you say that? I mean, does 79.3a not invite the tribunal to form a view on a sliding scale as to strength or weakness?
No, we say not.
And so, what about 79.3b? I mean, that requires the tribunal to form a view as to the impracticability, in essence, doesn't it?
Yes, it does. I accept that in relation to practice. But strength, well, the reason is...
So the draftsman's used two different drafting techniques in the same rule?
No, I don't think that's... I think practicability is ostensibly pretty binary as well, actually, whether it is practicable for them to be brought in all the circumstances. So it's either practicable or it's not.
But you say that the tribunal can't look at, quotes, the weakness of the claim as opposed to the strength of the claim.
No, I do, and I say that really as a matter of basic, well, I say that because of the approach that's set down in Merrick's, which I think shows that the courts should not be looking at, it's clear from Merrick's that the Supreme Court majority did not regard it as appropriate to delve into the merits. It's an assessment at the interlocutory stage of the merits. And I also say that as a matter of...
from interpreting the rules, which I thought is where you kicked off.
Well, yes, but I think that the rules have to be also interpreted in light of basic principles. And one of the basic principles that the courts apply is that you do not typically look at strength, certainly in a negative connotation of strength, at an interlocutory stage, because you're prejudging the issue. That's why when a case passes the summary judgment test, the judges in this jurisdiction are always very astute, in my experience, to make sure that they don't comment unduly on the merits of the case. They don't say
that's for a different purpose, isn't it?
Well, I think
You're letting loose a juggernaut here on an aggregate damages claim. I mean,
Well, I respectfully suggest it's not appropriate for a court at an interlocutory stage to seek to prejudge a case by labelling it as weak. And it does use the term strength. It does not
You're
use the
saying
term
it can
strength
prejudge.
or weakness.
You say it can prejudge it if it's
Well,
thinks it's a
it
strong
can
claim,
take-
but not if it's a weak. So it's a
I-
one-way street. You
I
say.
say it's a one-way street. I say that it's strength, and that's why it doesn't say the merits of the claim. It says the strength. It says strength, which suggests that in some cases you can say on a relatively superficial basis, this looks like a strong claim, and that is a factor in favour of opt-out.
So does it run like this
Yes.
in a case such as the present case where there was no application to strike out?
Yes,
There was no application for summary judgment.
no, exactly.
The tribunal, in assessing strength, simply looks at the threshold issue as to whether there's a real prospect of success.
Yes.
And having done that,
It
it doesn't go any further than
It
that.
can go one step further. It can then say, let's look at something. Well, let's take the
Well,
fact.
it's paragraph 106,
Yes.
I think. where
106, yes.
We said you could go further in an appropriate case, but
That's right.
the combination of 105 and 108 is that, save in those sorts of cases where
Yes.
you can say, well, this is really a very strong case because of
That's
X,
right.
Y, and Z.
Yes,
If all you're looking at is real prospect of success, there is no additional threshold
correct.
so as far as the strength of the case is
And
concerned.
that's why this is not something I invented. I'm saying that I extrapolate it from what you've said already. And it's right also, as I say, as a matter of principle, because the court shouldn't be stigmatising claims as weak at an interlocutory stage if they pass the summary judgment test. And that is surely the whole message of course Merrick's didn't, there was no,
The difficulty, I mean, it's a complication. They haven't found that it's weak. They've said provisionally we think it's weak. You're on notice. You can amend, subject to there being any viability to do so. Set that aside. We've discussed it.
well,
But we obviously can see what they've said. They were sceptical. They were critical of the pleadings. But they then said, we're very clear we're not going to strike it out. So we're left in the difficult situation that they've ummed and ahed and they've shrugged their shoulders and raised their eyebrows at you. But they've then said, you can have another go. Now, you're entitled to say, having only expressed by definition a provisional view, because it can't be anything else, they couldn't and shouldn't have taken it into account because it's only provisional.
well, I absolutely say that, and they did take, and they did, but they do say it's weak. They say that, and they make this is the oddest thing about this judgment. Is
I
that
know, they have their cake and they eat it.
They have their
It's
cake
like
and eat it.
it's sort of dare to and defend strike, isn't it?
I'm afraid it
You
is.
say, well, actually, it is strikeoutable. We're not going to strike it out
Yes,
for the following reasons, and then come back to it later on and say, oh yes, but so weak it could be struck out.
absolutely. And in circumstances where they haven't given us a fair procedural,
Well,
that's another issue. But then,
separate issue here
but-
about whether they really should have gone on to deal with opt-in versus opt-out
yes,
when they were not, when they were
absolutely.
saying you should have an opportunity to
Yes,
set
but
your case right.
that's right. But I want to go further because I want to show you that they are completely wrong in their assessment that these claims were in any way even close to being strikeable. They are absolutely validly pleaded claims.
You're going to have to grapple with this, that we have to decide whether, on one level, you can say they were wrong to defer. Never mind that they deferred you into a ditch you could never get out of.
Yes.
But in principle, they took a case management decision that all they were saying was, we don't like your pleading. And they said, we're not going to do it for you.
Well,
And we can't, at the moment, see our way through how we case manage this. So we're going to defer. Now, again, set everything else aside. That's got to be the target because,
well, my lord,
Isn't that a
can I
case
say,
management
I think
decision?
your lordship is being too charitable to the to the tribunal below because they do say these claims are apt to be struck out, and as I will show you, and they go on
We
and
understand all
they
the
go on
contradictions.
to invoke that, and they stigmatise these claims as very weak, and they
then
do
go
so.
say, we are very clear that we shouldn't, they say.
Well, they say they don't hesitate to take it into account on the opt-in, opt-out.
Absolutely, but that's the separate argument
Yes.
you've got. We understand that.
Yes, they don't actually strike them out, but then they do effectively strike them. But may I just,
So you say there are two errors really, is this right?
Mm.
The one error is embarking on this at all in circumstances where they said we're not going to strike it out. You can improve your pleaded case, in which case they should simply have deferred. The other argument is having then embarked on it, the one thing they couldn't do or shouldn't do is to say, well, actually this is a very weak case, therefore it should be opt-in rather than opt-out.
well,
And on that second point,
yes,
you say, well, it's an incorrect approach as a matter of law. They've misdirected themselves.
Yes.
But also it's actually completely wrong.
yes. Yes, I put the point slightly in a slightly different order, but I think that effectively encapsulates
So to the
it.
extent that it's a case management decision
Yes,
in relation to which we've said time and again
yes,
that this court won't interfere,
yes.
particularly in this sort of case
yes,
with the expert tribunal and all the rest of it.
yes.
You say, well, actually this is an example where even though it may have been a case management decision, they simply got it completely wrong or
Completely wrong.
whatever,
Yes.
whatever.
Yes.
But on
Right,
opt-in,
test.
opt-out, I mean, we have to distinguish in our own minds. I know you're wrapping it up together.
Well, I didn't wrap it up together. The tribunal wraps it up together because I want to show you how
Yeah,
they deal
well,
with
I
it.
understand.
Because it's quite
But you still have
extraordinary.
to then persuade us that
Yes,
you know they haven't struck you out. They've just simply deferred. So you've got to then say,
yes,
on the basis of the pleading as it was before the tribunal,
Mm.
they should, in principle, have there and then have said it's sufficient, as opposed to saying, scratch our heads, we can't quite
Yes.
see our way through it, we're going to
Right.
defer.
these are completely validly
Yeah.
pleaded.
But we're not
Causes of
applying a
action.
strikeout appeal, when we might actually say, what is the bare minimum standard a pleading must reach before
Well,
we say it's viable?
Except this, that what they do is they say is that it is one of that there are two limbs to their
Yeah.
finding of finding that there should be opt-in. One is practicability, and the other is strength. And they say they say strength. They say is points very strongly. That's what they say in paragraph 385 in favour of opt-out. So it is part of the ratio of their decision that strength, or actually weakness, is what of these claims points to opt-out. It's part of the ratio. It's one of the two.
Opt-in, yeah.
Forgive me, opt-in. Forgive points to opt-in. And they say that they don't just say use the expression weakness. They say they are apt to be struck out.
Yeah.
So the finding that they are apt to be struck out is a stepping stone in their actual decision. One of the two essential stepping stones in the actual decision to rule that this is an opt-in claim, and thereby stymie it.
Yeah.
And that's where your lordship's expression "willing to wound but afraid to strike" is absolutely right, because they stand back from the strikeout because they know that they haven't dealt with it procedurally properly. But then they use that same finding that it's apt for strikeout as one of the two limbs, finding that it should be opt-in, and stymieing it indirectly. So yes, my lord, yes.
So is this right? So
Yes.
if the tribunal said this is a perfectly arguable case, there's no question of striking it out,
Yes.
but it's just over the line, you'd say that's illegitimate for them then to take into account on the opt-in,
Yes,
opt-out question.
I do.
And you say they can only do it if they say, not only is it just over the line, it's a long way over the line, it's a really strong case, therefore it ought to be opt-out.
That's right. That's how it should operate, and that's in
And
accordance.
that's the effect of what
That's the
we said
effect
in
of
paragraph 106
Exactly.
and 108 of
And
Patrol.
But
absolutely.
you don't in fact get that, or do you in fact get that from the rule, or do you get it from the judgment in the Patrol?
I think one gets it in part from the rule because the rule does use the term strength. It doesn't say the merits. It doesn't say strength or weakness. It says strength. So that's an indicator. And secondly, one takes it from the basic principle of fairness that courts shouldn't. They should hold their tongue at an interlocutory stage on the merits.
Understand that.
Yeah.
Yeah.
If the defendants win on strikeout, and it is struck out, then opt-in, opt-out is completely irrelevant. The case is dead anyway.
Absolutely.
So let's assume, on the hypothesis that it survives and it's arguable, meets the threshold.
Yes.
why does it impact either way on opt-in or opt-out? Because the basic merits have to be tried and they're a constant. Well, how does it shift the balance? I mean,
Yes, well,
both in terms of administration of the claim and the intrinsic merit. What is that tilting factor which is said to be relevant?
well, I think all one can say is that we say that actually, as you found in Le Patrel, that strength is a relatively limited factor. It will apply in limited circumstances where you can clearly perceive on a rough and ready high level that there are features of the case that make it strong, and that's as far as the court should go. Now, is this such a case?
So why is it right for the court to be able to not hold its tongue in that sense, but has to hold its tongue in the other sense?
Well, because it's simply saying it's only giving a very high level.
Yeah, but okay, but if it's legitimate for it to say at a high level it's strong, why isn't it legitimate to say at a high level it's over the line but weak?
Well, because saying that it's strong on a relatively sort of obvious basis doesn't prejudge the proceedings.
Well,
in a
which
way
case,
that-
why does it prejudge?
Well, it does prejudge them. If you say that a claim, particularly a collective claim, is weak or very weak, you're going to undermine the viability of the claim.
Well, and if you say it's strong, you're going to undermine the viability of the defence. I mean,
Well, you might say, well, maybe the draftsman should have said the strength or weakness of the claims, but they didn't. They said the strength of the claims, and I suggest that indicates that it was intended to look at it in that way. And I also say that there is a difference between saying something is a claim is at an interlocutory stage is, look, this looks strong because it's based on an infringement decision, or there have been huge settlements in other jurisdictions on the same claims, or those sorts of grounds. There's a very big qualitative difference between that and saying to a claimant, well, we just don't think you're going to get the evidence to make good your claim, or look at this all looks incredibly difficult for us. That's not appropriate for a court to do on an interlocutory basis.
In merits, the court said in the context of a follow-on claim that if there was, quote, some evidence,
Yes,
then it needed to proceed.
exactly.
But I mean, I can see that, let's assume you have, for the sake of argument, a follow-on decision on effects, not object. And there's a detailed analysis of the facts which sets out in more quantitatively measured terms the impact upon the potential claimant in the proceedings.
Yes.
And there could even be, for the purpose of establishing effect on trade or competition, you could almost measure it. You may have a really detailed decision which does 9/10 of the work because its effects. Now, in those circumstances, does that decision become more relevant to opt-in or opt-out, or is it still neutral? Because I'm still a bit unclear in my own mind as to what weight the merits have in the scales of the relative benefits of opt-in or opt-out.
Well, it's not the merits; it's the strength, and I think that
I'm calling this a strong
I do
case.
think that is. I do think the draftsman, used that phrase deliberately, and it is strength in limited circumstances where you can say at a high level that it's clear. And I'm not sure that I can comment on a kind of hypothetical example of but it might be that the precise terms of a infringement decision might give you basis to say, well, it looks very strong because
Let's assume that.
yes.
How does then go the further step into deciding opt-in or opt-out? Why does it make a difference? Maybe if you've got something which is compelling, it might make
Yes.
opt-in a bit more easy.
Well, here I'm afraid I hit bedrock because I'm not the draftsman of the statute, but because maybe strength shouldn't be a criteria but it is, and so I think one has to accept that it is a factor, and one can't say strength is a factor that it seems implausible to say that strength is a factor that favours opt-in. If anything, would favour, it seems, opt-out. That does seem natural, but it must be handled with a long spoon. Because it's
All 79.3 says is that it's a factor. I mean, it doesn't
that may be
say-
taken into account.
Yeah, it doesn't say it's a main factor. It doesn't
No.
actually attribute extra weight. It's
No, it doesn't.
For clarity, it is
No.
a factor which may be taken.
It may be taken into account, exactly. And so sort of at a very high level, we say, essentially there were two, if one takes the right approach, this high level approach, looking at strength, the most obvious, if you take the circumstances, what are the obvious circumstances of these claims? Well, they're based on two infringement decisions, they're settlement decisions, so they are, in accordance with Volvo and Ryder, binding in their entirety. You'll see various places in the papers where they are summarized, but in the broadest of terms, what they record are recurrent, almost daily exchanges of highly confidential, price-sensitive trading information by a group of senior traders of the largest banks, or some of the largest banks in the market, going on over a period of many years. So you've got a formidable settlement decision base. You then got the fact that the O'Higgins application was supported by detailed expert reports from two independent experts. And it's really hard to conceive of experts who are of greater distinction in their respective fields. One of them is Professor Breeden, who studies the particular markets in question. He is an expert in FX microstructure and trading, and indeed is also a former trader and someone who worked at the Bank of England. And the other is Professor Bernheim, who is the chair of the Department of Economics at Stanford University, who studies the economic effects of cartels and has enormous experience in studying their econometric effect. These are distinguished academics with reputations to preserve. They are not hired guns. And it's difficult to think of more distinguished or appropriate ones. And their expert reports, some of which, but not all of which, are in the bundles, explain in detail, and by reference both to the relevant markets and the facts of the infringements, the mechanisms by which the infringements were liable to have caused loss to the class. And they also describe in great detail the methodology by which the extent of such loss caused by the infringements could and would be measured and evaluated. And they describe the documents and the data that would be available for that purpose. Now, the respondents put in no expert evidence at all in response.
Are you going to take us to some of those?
I am.
Yeah.
Yes. And those experts were briefly questioned by the respondents' counsel during the hearing. There was no serious attempt made to undermine their testimony. It was never put to them that they were unqualified, or even that their approach was obviously wrong or bound to be unworkable. No application was made by any of the defendants for strikeout or reverse summary judgment, and no allegation was made by the defendants that the Microsoft process test was not passed. And another factor one can't lose sight of is what Mr. Lomas observes in paragraph 456 of his dissenting judgment. He says that there have been similar class action claims based on related infringements in other jurisdictions, which have led these and other banks to pay out over $2 billion in compensation. Now, in those circumstances, there were only two ways open on the law and the facts for the tribunal lawfully to approach the strength factor. Most obviously, they could have found that the strength factor at a high level favoured opt-out. Alternatively, I might perhaps be prepared to concede that it might have been at least open to the tribunal to say, well, I see all of those factors favouring strength, but nonetheless, the technical complexity of proof and the early stage of the proceedings means that it's not possible to form a reliable view of the merits or of the strength of the case. And on that basis, we will say that the strength factor is neutral. Now, those were the two options open to the tribunal. It was not open to the tribunal to do what they did, which is to find that the claims were so extremely weak that they merited strikeout, and that their supposed weakness was a factor that favoured opt-in. And I want to say
We'll
that
come back to we can deal with that. I'm still. Let's assume you're correct, and let's assume that we were sitting in the category. We're looking at the category. We come to the conclusion that this case should have met the arguability threshold, the strikeout threshold. They still haven't struck you out, and in 3 months' time, depending on what happens in this court, you go back and you put in a pleading and you cite the Essex lads, ad infinitum, and then they strike you out.
Yes,
Isn't
but
our test and our
Well,
approach then different?
Well, I want to avoid that because I think that would be a very long
Yeah.
process. And basically, I think that what this court, with respect, needs to do is to correct some of the errors of approach to strike out and to these pleadings to prevent that sort of repeat
And how do we do that?
performance. Well, let me take you through the errors of approach, and then.
Well, we could do it two ways, couldn't
Yes.
we? We could go with you all the way, as it were, and
Yes.
allow the appeal on this ground.
Yes.
Or we could say, well, it was a case management decision for the tribunal. We haven't actually struck you out, but their approach seems to us to have errors in it, and therefore we could give them guidance as to what
Yes.
the correct approach
Yes.
would have been,
Well,
which might or might not avoid a further round of pleading.
no. Well, indeed.
We could, as a third option, say your case is pants and we just dismiss your
Yeah.
appeal.
Well, I'm not in favour of that last part. But we do say that we do say that the tribunal should and that this court should correct the tribunal because as I said, it's not as though this is some sort of obiter. This is part of the ratio of their judgment, as I will show you on
Opt-out, opt-in.
Yes.
Let's assume, for the sake of argument, we're with you on that, and we're now
Yes.
looking at the importance of the strength
Yes.
to these considerations which arise.
Yes.
And we say, well, perhaps for the sake, they
Yeah.
shouldn't have come to this view, it was premature, what have you.
Yes.
Given that it was accepted that it was non-viable, that was
Yeah.
highly relevant. We're then left with the question, what do we say about the merits? We could simply say, well, then we're just focusing upon the fact that they grumbled at you but deferred.
Well, can I suggest, let me take you through it, if I may, and then, of course, you will decide how far you wish to go.
We've got
But
also,
also, just before you take
Yes,
us through,
yes.
I mean, there was a question from me about whether you've got all the documents you need, in the sense that I got the impression that because of the decision on opt-in, opt-out, your side collectively had not produced your re-pleaded case, for want of a better expression. There was something more to come if it had been certified on an opt-out basis. There would have been something else that the CAT was clearly searching for. I mean, is that right or is that wrong?
Well, the notion that there was something else that they're searching for is something that comes entirely in the judgment. It was, if you like, it was news to us. We were asked post-hearing,
Yeah, you were asked, there was a letter sent. and-
please send us a further pleading setting out your case on causation, which we both did. The notion that then there should be something further is something that they set up in the judgment, but it's very unclear. First of all, they say it's not for us to say what it is we're looking for, and they also say in the judgment, well, it's not clear that you can, in this type of case, translate economic theory into averments. So we're not even saying it can be done. We think it probably can't be done. But we're going to give you a further opportunity, but only on an opt-in basis.
But I suppose what I'm really asking is, if this appeal was on your favour on the opt-out point,
Yes.
such that the collective proceedings go forward on an opt-out basis,
Yes.
is there then a next set of documents that your side would be producing,
Well,
or not? Because if you say no, this is what we've got here is, all we would give at this stage,
well, other than this,
then in a sense that's
Yes.
one position for this court to be in.
yes.
If you're saying, oh no, actually, if we've got the right decision on the opt-out basis, we would have set two, which is, I thought, what I heard Ms. Wakefield say at one point. Maybe I misheard her.
Yes. No, I think
Then in a sense, why shouldn't we have that if we're to say anything more about it? Because it would be shooting at the wrong target, wouldn't it, if
Yes.
we don't have it?
no, but
You may
well,
want to
let me be clear. From our point of view, from Higgins, is there's one proviso, but other than that proviso, we say that our claim, as pleaded before the tribunal, including the causation document that we provided them with, and even actually before that, is a perfectly complete, non-demurrable, arguable claim, and we don't need anything further. we don't need any opportunity further to replead, because we have pleaded a complete and plausible cause of action.
Yeah,
Of
when you say
course.
non-demurrable,
Yes.
I understand you say what you've got is sufficient to survive a
Yes.
strikeout application
Yes.
which hasn't been brought.
Yes.
That's not
Yes.
quite the same question of what, if anything, we say about quotes merits, unquotes.
Well, it effectively is, because in my respectful submission, because the way they put it is they say that this was apt for strikeout.
Right,
So we say it
you're
was not
saying
apt for
this
strikeout.
court should only take a view on opt-in, opt-out and strikeout ability. That's
Yes.
as far as it goes.
Yes.
And say nothing else for the guidance of the CAT on how to carry on dealing with the deficiencies that the CAT plainly thought existed, other than I think at least one of you wants it sent back to a different CAT.
Well, we do because we say that because they have prejudged the merits in a way that is not acceptable, and gives rise to an appearance of bias. I'm afraid.
Okay,
But secondly,
so you say this court shouldn't say anything to guide whatever constitution of CAT next encounters this case on the approach to.
Of course, there are all sorts of things that the CAT might wish to do in the future to case manage the proceedings, but we don't think that there is any flaw in the pleadings.
But your
So-
primary point, the point I put to you a moment ago, your primary point is that they erred in concluding that your pleading was strikeout.
Strikeable, yes.
Full stop. It's
Yes.
just your plea, whether it's your pleading or Mr. Wakefield's pleading.
Yes.
They're both perfectly acceptable pleadings which have a real prospect of
Yes.
success.
Yes.
If you're right about that, then the
Yes.
conclusion should be that
Yeah.
that's what they should have concluded.
That's right.
And you wouldn't need any more than that, because there won't be some second round of pleadings
Exactly.
before whichever CAT.
Exactly.
If you're wrong about that,
Yes.
and we were to say, well, this sort of
Yes.
dare to wound, fear to strike approach is a
Yes.
case management decision, which was
Yes.
for the CAT, and they haven't actually struck you out.
Yes.
So what's
Yes.
the problem?
Yes.
Then I think you would at that stage
Yes.
invite this court to say, however, we think there are the following problems with the approach that's been adopted
Yes,
by
I would.
this.
If I may, can I just before the short adjournment, just briefly say what we say are the three main errors with the judgment. So, and I think they are perhaps similar to the points that your Lordship has put, but in a slightly different order. First of all, we say that they err in their approach to the strength factor. Now, the tribunal's articulation of its approach to that factor isn't entirely easy to pin down in the judgment, because there are a number of different statements, some of which appear to be contradictory. But where the tribunal appears to come out is, first of all, it takes the view that an opt-out claim needs to earn the benefits of opt-out certification, which are apparently to be identified by reference to the dissenting judgments or judgment of Lord Sales and Lord Leggett in Merricks, the so-called leverage of opt-out proceedings. Next, and on that basis, it seems to find that to be strong for the purposes of the strength criteria, a claim has got to meet a standard that is equivalent to the good arguable case standard of showing it has the better of the argument on the material available that will be familiar to the court from the gateway test in jurisdiction claims. And also that the tribunal should or can also consider the probability of the evidence emerging that would be needed for the claim to succeed. So that seems to be its approach to strength. And then it goes on to see its approach also as not just, as I said, not just assessing strength, but also whether the claim is weak. It seems to effectively to identify a scale. And if a claim is assessed as weak, then that's a point in favour of opt-in and against opt-out. And we say that approach is inconsistent with Paturel and it's wrong in law. There is no good arguable case test that an opt-out claim should meet or should generally meet. And the tribunal shouldn't be stigmatizing claims by labeling them as weak at an interlocutory stage under the rubric of the strength factor. Now, the second error we say the court made was in holding that the claims were worthy of strikeout, and I'm going to take you through.
And you look at footnote 152,
I will do.
because they don't say that, they say the opposite there.
I will.
375 though, you may want to look
Yes.
at that. I mean, this is, you may say there are some inconsistencies in the
There
way
are.
they express
No,
themselves.
there are, but you have to
Snuck
look
something
also.
into a footnote.
Yeah, well, I'll have it, but there are inconsistencies, and but you have to look at what the cat did as well as what it said,
Yeah.
because what it did was undoubtedly to say this is weak, very weak, and that's the reason for opt-in. It says that in terms. And we
I think conceptually that's a different point, because if they're saying
yes.
you can have another go,
Mm.
and we're not saying it's weak because we express no view about the merits. You say, well, inconsistency, then look what they did on opt-in, opt-out.
Yes.
So we can say, right, that's an error, but then you come back to what do they say about the merits? All they've done is say, well, we're very clear in our own minds that we're not expressing any view on the merits.
Yeah.
It's a pleadings point only, they say in 152.
Oh yes. Well, yes. They do say that it's not.
But having said that, albeit in a footnote, you say, well, what they shouldn't have then done
No.
is to come, as it were, come back round it
No, they-
under the opt-in versus opt-out point.
Can't
They're
feed
not,
it in
they're
there.
not, when they say they're looking at the pleadings only, I mean, there's a completely pleaded cause of action. They're just looking at the prospects of success of this cause of action or the difficulties of proof. We'll see that in a moment. Thirdly, in reaching its conclusion on strikeout and the strength of the claims, the tribunal adopted a procedure that was completely contrary to natural justice, because they recognised that the nature of their objections, which led to their conclusion on strikeout, hadn't properly crystallised until they gave judgment. They're only articulated in the judgment itself, and that's why they decline to strike out. So that's why they make their decision on strikeout provisional. But then they got no hesitation in invoking that same conclusion when it comes to the certification decision on whether it should be opt-in or opt-out. And that's not a provisional decision, that's a final decision. And the effect of that is that the proceedings don't proceed at all. So they de facto struck out the claims. And yet they did that without giving us, either us or Evans, a fair opportunity to address them on the specific concerns, the supposed demurrability of the claims, that led to that conclusion. So we say very simply that if fairness required them to stay their hand before striking out, then obviously fairness also required them to stay their hands before stymieing the claim by a different route. And we also say that they should have reached a provisional conclusion and actually not even put their views in a judgment. They should have put the points to us and allowed us to have a further hearing to address them. So that's an overview of the 3 points, and I hope I'll try to run as fast as I can this afternoon. There is a lot to get to, I have to warn you.
2 then, please.
Okay.
All right.
Terrible.
Not chasing you, because there were lots of interventions. I need the rest of the day.